All right, well, good afternoon, everyone. Appreciate y'all taking the time to pop in here. Especially thankful for our board members, our fellow managers for taking time out of your busy day to join us for today's webinar, proudly hosted by EJF Real Estate Services. My name is Joshua Martinez, and I am the Hampton Roads Regional Manager here at EJF. We're excited to have you with us. We dive into an important topic today, achieving community association success through practical tips for collections, compliance, and meetings. We're incredibly fortunate to be joined today by two highly respected experts in the field, Mr. Greg Bean and Mr. Brett Herbert, both partners at the prestigious Gordon Reese Scully Manskahani law firm. Take a couple minutes here just to briefly introduce our speakers. Mr. Greg Bean focuses a significant portion of his legal practice on representing community associations and developers with experience in both bankruptcy and construction law. Greg is particularly skilled at filing proofs of claim and seeking relief from the automatic stay to enforce the covenants, an incredibly valuable asset to our communities. And then Mr. Brett Herbert serves as legal counsel to numerous community associations throughout Virginia, small and large. His areas of focus include general legal guidance, document interpretation, amendments, enforcement, and collections. His practical insights are sure to be beneficial to all of us. And we are truly thrilled to have Greg and Brett partner with EJF to continue providing outgoing and ongoing educational opportunities for our clients across the state of Virginia. Today's session is going to include actionable strategies, real-world guidance, and we'll conclude with 10 to 15 minutes of Q&A. If we run out of time and your question isn't addressed live, please drop it into the chat. We'll make sure it gets passed along to our speakers and that you receive a follow-up response. And once again, Greg, Brett, thank you again for sharing your time, expertise with us today. And with that, I will turn it over to you.
Perfect. Thanks, Josh. I'll introduce myself and then I'll allow Brett to introduce myself, and then he's going to kick it off, and then I'll finish with the tail end. So just like Josh said, Brett and I are attorneys at Gordon Reese, and we a large part of our practice is helping community associations to manage the legal realm and kind of support Josh and his team and other managers throughout the state. And so we're happy to present today, go a little bit more in depth on some strategies you can use to assist in your being board members and managers and really helping you out there. So we want this to be open. So we'll definitely do question and answer at the end. But if you have a question, you can type it in the chat or raise your hand. I think probably people are muted for now, but I think if you put your question in the chat, we can keep monitoring those. You know, one of the best ways we can learn is by answering your specific questions about certain things. So if you have a burning question, feel free to chime in and we can go ahead and address it. I've been practicing for about 14 years now. I grew up in Idaho, came out to Virginia, love it out here. Got bunch of kids, 5 kids, and so I got this helps me keep food on the table. So I appreciate everybody's time, and I will flip it over to Brett, and then we'll get started.
All right, thank you, Greg. Thank you, Josh. Thank you, Lynn. Appreciate the opportunity to be with you all today and to cover some pretty timely topics, some recent legal updates from the Virginia General Assembly. So, as Josh and Greg mentioned, my name is Brett Herbert. I'm a partner at Gordon Reese, resident in the Williamsburg office, and have been practicing in this area of law over 9 years at this point, and looking forward to the discussion today. So I understand we've got a PowerPoint presentation that Greg or Josh will be able to share on the screen. So we're going to be rolling through that. I understand these will be made available after the presentation, so you don't need to feel like you need to scramble notes down just to get it. I do believe it'll be circulated. So with that said, I'm happy to go ahead and kick this off. I know we've got limited time, so let's jump right in. So the first category or first sort of topic we're going to be covering today is just some sort of basics in collections and covenant violations. And Greg's going to talk a bit more about meetings, executive session, and director issues. So just regrouping, kind of starting right from the top. I know most of you all on this call already know this, probably have already taken a Board 101 type class, but for the board members out there, whenever we're discussing really anything the board is doing, it's always important to understand and keep the perspective that you as a director are operating as a fiduciary. And there are certain fiduciary duties that you as directors owe to the association. And you can think of this as sort of a trustee-like relationship, that this is a heightened duty of care and of loyalty to the association that you owe as directors, as opposed to just sort of an arm's length transaction with a third party. And so the advice we're going to be giving today is always through that lens. And so a way to summarize it is you as directors have a duty to act in the best interests of the community as a whole, a duty to treat all owners equally, a duty not to self-deal or engage in conflicts of interest. And this also has an impact on how boards enforce collections and enforce covenant violations. So the three main duties, fiduciary duties, we always want to mention in these trainings, these webinars: the duty of care, the duty of loyalty, the duty of confidentiality. These are duties that you as directors owe to the association itself. The duty of care, is a way to summarize that, is a duty to do your job, a duty to follow what the governing documents require, the duty to engage in good faith exercise of those duties. For example, if there's an issue of should we engage in this third party contract with this landscape company, it's probably a good idea to get several bids. It's probably a good idea to get references for that landscape company that you may be considering. Those are things that help you carry out your duty of care. Your duty of loyalty relates to, kind of self-explanatory, your duty of loyalty to the association, avoiding self-interested transactions, conflicts of interest. If you're a director and you have a personal interest in an issue that the board is voting on, you should probably recuse yourself from that vote, things like that. Duty of confidentiality is just what it sounds like, a duty to keep board information or legally privileged information or proprietary information within the board itself and not share it with neighbors or friends who may live in the community that don't otherwise have a reason to have that information. And so all three of these duties carry over into the context of what we're going to be talking today: collections and covenant violations. So talking collections, this is obviously a hot button issue. Most associations, unfortunately, run into issues where owners don't pay. And so it's something that Greg and I work with routinely to help clients through that process. So again, keeping these fiduciary duties in mind when handling collections, the boards do have a legal duty to pursue delinquent assessments. Although sometimes it can be uncomfortable or awkward or expensive, the board does have a duty to do so uniformly. A duty to do so within the applicable statute of limitations, which we're going to talk about in a bit, is 3 years. So in Virginia, 3-year statute of limitations for delinquent assessments. Sometimes we run into associations, unfortunately, who don't seek a judgment within that time period and are precluded from seeking those assessments older than 3 years. So it's important to keep that in mind. And also diligently pursuing the collections as part of their ongoing duty of care. I know oftentimes associations have recurring agenda items on their board meeting agendas to go over the delinquency report. What are we doing on these collections? What's the update from the attorney? Are there any that we want to assign to the attorney or the collections agency to pursue? So just keeping those current, keeping those on discussion at board meetings is a good idea. And unfortunately, the failure to do that, and unfortunately for directors who don't do that, it could open those directors up to a potential lawsuit or a claim for a breach of fiduciary duty. So very important to stay diligent on those. So some basic collections principles we wanted to go over. Typically, and Greg and I represent clients on collections matters quite often and have for a good long time. Typically, the process looks like this. The account is turned over to collections counsel. Collections counsel reviews the account statement to see what's being charged, how old they are there any entries that may need further review. And remember, a 3-year statute of limitations on collections of delinquent assessments. So there's assessments that are about 2 years old and they're still unpaid and there's no judgment relating to those or no memorandum of lien. Probably a good idea to start talking with your collections counsel about what the plan is to address those. So on our end, what we typically do is we draft an initial demand letter to the owner, and sometimes that does work. They'll end up paying in full, and that's the end of the matter. As a precursor to that, I jumped ahead of myself a bit. We do a PACER bankruptcy search. PACER is the federal court case information system. And the reason we have to do that, and some of you all likely know this already, is that if an owner's in bankruptcy, there is a stay, an automatic stay that the bankruptcy court imposes on all creditors, essentially saying you cannot pursue collections on this debt except through the bankruptcy process. And that's where lawyers like Greg come in. He's got great experience with bankruptcy proceedings, where if you do have an owner who's in bankruptcy who hasn't been paying, there are options such as filing a proof of claim and pursuing that assessment through the bankruptcy process. But if an owner is in bankruptcy, that's going to prevent the association from filing a lawsuit in state court or from recording a memorandum of lien while that bankruptcy is pending. So that's why we do that on our end as well. So if the demand letter doesn't work to the owner, they still don't pay, or they make a payment that's not sufficient to the association's satisfaction, there's several different options, sort of long-term in the collection process. But the two right away that we most often recommend are a warrant in debt, a lawsuit in general district court, and or a memorandum of lien. These can be done at the same time. These can be done one or the other. It's really dependent on the association and what the association's objectives are. There are benefits of both. There are cons of both that we can go over more here in a bit more detail. There also is a process to foreclose the memorandum of lien if that remains unpaid after a period of time. We'll talk about that. And sort of the nuclear option that comes up rarely, but sometimes it does, is what's called a judgment creditor suit. And a judgment creditor suit, which we'll talk more about later, is essentially a lawsuit in circuit court that says, Judge, we have these judgments against this property, against this owner. They still have not paid. There's no hope they're going to pay. They've made no effort. We would like the court to order the sale of the real estate to pay this judgment lien and any other liens that may be encumbering the property. And we'll talk through the process on that a bit later. And the law has changed on that significantly recently, and we'll go over that as well. So starting right from the top on when we get a file in our office, just a way to give you some more detail on what collections counsel is going to be looking at and which they should be looking at. So the account statement is going to itemize the different assessments that may be charged, the different charges that may be charged by an association under their governing docs. For example, we often see late fees, we often see interest, we often see appropriate attorney's fees or a collection referral fee if that's provided for in the declaration. But we frequently see charges and fees on account statements of associations that are simply not provided for under Virginia law and under the declaration. And it's important for us to have that discussion with the client, explain why that is, and give some recommendations of, hey, we think you need to remove that off the account statement. We don't think we can legally collect that. And there's legal exposure to the association if they try to do that. And the reason for that is not only under the Federal Fair Debt Collection Practices Act, which we'll talk about in a bit, but also this Virginia Code section that's relatively recent within the last several years. And in the Property Owners Association context, it's 55.1-1805. And it essentially precludes an association from making any charges that aren't assessments unless they're authorized under the POA Act or the declaration itself, or otherwise provided by law. And so essentially for the property owners associations out there, what that means in part is that you can't rely on, let's say, a late fee that's only in the bylaws or that's only in the rules. That is not legally sufficient. It needs to be in the declaration itself or otherwise authorized by law. And that is a way that associations can find themselves getting in trouble if they try to pursue that without having that discussion with their collections counsel. So community managers, they often represent multiple associations. Some governing docs provide authority for those, others don't. It's always a good idea to check beforehand. And that's something that we and all collections counsel that are capable should be doing at the outset. So again, late fees, administrative fees, be on the lookout for things like that and have that discussion with your collections counsel if appropriate. And the reason that's important is that code provision, and there's a similar one in the Condo Act, it does provide that the CIC board which is an administrative board in Virginia that sort of oversees property owners associations, condominium associations. They can actually impose penalties on the associations and community managers who don't comply with that statute. So that statute does have some legal exposure if that's violated. So that's important to keep in mind. Go ahead, Greg. So option number one, memorandum of lien. So most of you are probably familiar with this. There is a process under the Property Owners Association Act for, and Condo Act as well, condominium associations as well in a different code section, that allows a memorandum of lien to be recorded in the clerk's office, provided in the Property Owners Association Act context, you give at least 10 days written notice by certified mail. And so for us, because we're collections counsel, when we do this, we have to give at least 35 days notice under the Federal Fair Debt Collections Practices Act, which we'll talk about a bit more. So practically speaking, it's about a 35-day notice. If they don't pay, the law allows a property owners association to record a memorandum of lien in the circuit court clerk's office that goes back and captures 12 months of delinquent assessments. Anything older than 12 months cannot be recorded on a memorandum of lien. You can sue for it, provided it's less than 3 years old, but you can't put it on a memorandum of lien. The benefit of a memorandum of lien is it's not a lawsuit. If they don't pay, you have the authority to draft one and record it with your collections counsel. And it used to be that under the old law, that memorandum of lien was good for 36 months. Why they didn't just say 3 years, I don't know, but they said 36 months. Now the law has changed in favor of associations, which is good news. They are now good for 120 months or 10 years. So we have some smaller associations who elect to just record memoranda of lien against properties when they don't pay, perhaps because the assessments aren't very high on an annual basis. And sometimes that's a decision those boards make. Sometimes, often, what we see is that association boards choose to pursue both a memorandum of lien and a warrant and debt at the same time. So we'll talk about warrants and debt here next. So option two, which again can be done at the same time as a warrant and debt, as a memorandum of lien, is a warrant and debt. Warrant and debt is a lawsuit in a Virginia General District Court. The General District Court in Virginia is the lower of two trial courts. So for General District Court, think the court you go to where you get a traffic ticket, or maybe where somebody gets sued for a credit card bill quite frequently. So we're looking at that court typically where we're suing for delinquent assessments. That court has jurisdiction to hear claims on delinquent assessments for up to $25,000. And quite often that's what we're looking at, somewhere $25,000 or less for almost all property associations that I think I've ever seen. So the benefit of filing a warrant and debt in Virginia General District Court is it's actually quite cost effective to do that. To draft it typically only takes a few $100s and get it filed. Once it's filed, the court's going to set what's called a return date hearing about a month later. At the return date hearing, the court's going to want to know, does the defendant contest this debt? Does the owner admit they owe the money? If so, the association can ask for a judgment right then and there. If the defendant doesn't appear, the association can ask for a judgment right then and there. If the defendant appears and contests it, what the court's going to do is probably set the matter for trial, usually a couple of months out, and order the parties to file written pleadings just explaining what the basis is for the claims and any defenses. The good news for associations as far as attorney's fees on warrants and debt is discovery is very limited. Discovery means the methods that parties in litigation are able to discover information from the other side or from third parties. Quite often, this takes the form of written discovery, interrogatories, requests for production of documents. It can also be depositions, third-party subpoenas. In General District Court, no written discovery is allowed, no depositions are allowed, only written document subpoenas to the other side or third parties for documents. So that helps keep costs typically much less or much lower than a circuit court or a higher court lawsuit. And the cost, as far as attorney's fees to do one of these and to obtain a judgment really depends almost entirely on how much resistance the other side or the owner puts up. If the owner doesn't show up or just admits the debt is owing, typically a judgment can be obtained for just several $100s. And quite often associations have attorney's fees shifting provisions in the declaration that allow the association to ask for an award of attorney's fees in court. Now, if an owner contests, hires a lawyer, puts the association through the ringer, makes it file a pleading, go to trial, then obviously the cost can be substantially more. You're probably looking at several $1,000s. Now, again, most associations, or many of them, have attorney's fee shifting provisions that allow you at trial to say, Judge, the association was put through the ringer here. They contested this. We prevailed. We would like an attorney's fees award of all of our attorney's fees. So it's a bit of a two-way street for owners if they show up to contest, because quite often they're looking at an attorney's fees award as well. So what happens when you win a lawsuit? So when you win a lawsuit, you get a monetary judgment. A monetary judgment is simply a judicial record or a document that memorializes the fact that the owner owes the money to the association. It doesn't mean the owner has to pay right away. It doesn't mean that the court orders them to pay or there's going to be some consequences for that. This can be very frustrating because this starts phase 2 of the collections process, that once you get a judgment, how do you set about paying it? Sometimes owners make payment, and that's great. And if they do, that's the end of the matter. But quite often they don't, and the association then is forced to enforce its judgment through post-judgment remedies, which we'll talk about here. Typically, they take the form of garnishment and or what's called debtors interrogatories, and we'll talk about those here in a moment. So debtors interrogatories, once we get a judgment, typically what we do is we ask the association, do you have any canceled checks or banking information or employment information for this owner? Because if you do, we can go directly to a garnishment of their bank account, of their wages. Potentially, if they own a rental property, we can try to garnish the rent that they may obtain by virtue of that rental property, and we can jump right to that. If the association doesn't have that information, then typically what we recommend is engage in a process called debtors interrogatories. And this is a fancy way of saying, Judge, we want this debtor, this owner, to come to court and tell us information about his or her financial status so that we can try to collect this debt. So debtors interrogatories is after you obtain a judgment, you can request a summons to the court for the debtor to show up and answer the questions of the collections counsel under oath. And if they don't, you can take them back in front of the court and say, Judge, they're refusing to answer the question. Please direct them to answer the question. And if they still refuse, the judge can hold them in contempt of court, which would be very bad for the owner. So sometimes owners get this debtors interrogatory summons and they don't want to come to court. They just tender payment or enter into a payment plan. And that's great. If they don't, then the debtors interrogatories process will proceed. We'll get hopefully information about their banking, about their employment if they're employed, and that will help to guide the further collection strategy, whether that's garnishment of wages or bank account, etc. So this can be a good tool because they do have to come to court, unlike in a warrant debt where they don't technically have to. And if they fail to appear, they open themselves up potentially to a show cause, which could ultimately, if the court so finds, they could be held in contempt. Garnishment. So this may be the most common post-judgment remedy. Again, if we have bank information, if we have employment information, we can jump directly to a garnishment. Garnishment is a post-remedy, essentially a lawsuit that takes the form of a filing with the court that says, Judge, we have a judgment against this owner. We think their employer or this bank is holding money for them or will pay them money if it's an employer that ought to be rightly paid towards the judgment. And the garnishment will then be served on what's called the garnishee, the bank or the employer quite often, and also the debtor themselves. And the garnishee is going to need to file a written response with the court stating whether or not they have any money that's due and owing or payable to the creditor. And if they do, they're going to need to pay that into court if it's a bank garnishment. If it's a wage garnishment, there is a rather complicated formula by statute that they have to follow as far as what may be garnishable. And typically, in the garnishment context, there are certain amounts of wages that are exempt from garnishment. I believe it's 40 hours a week at the current minimum wage, and then you can garnish a portion above that. So it's not always an option if the person is employed, because if they're not making sufficient assets or sufficient income, I should say, then sometimes the employer will just say, yes, they're employed here, but they don't make enough money to actually be subject to a wage garnishment. So all things being equal, a bank garnishment can sometimes be more effective because that allows you to make a claim for the entirety of those bank accounts. The owner could still try to file an exemption based on, oh, it's all wages that are in there, or it's an exempt amount of money in there. But I think the bank garnishment generally gives a good amount of leverage. The wage garnishment can be effective as well. Sometimes it can just take a bit longer. So by statute, a bank garnishment period can last up to 90 days. Essentially, any garnishment that isn't a wage garnishment can last up to 90 days. What that means is that you can't garnish their bank account forever. After 90 days, the garnishment is going to be released. You can file a new one after 90 days and continue to file them if it's yielding money, but you can't just do one and done. It's going to be limited to 90 days. For wage garnishments, conversely, it's going to be 180 days. So a little bit longer of a period of time. But again, if that's yielding success and you're getting some money in the door, you can always do another wage garnishment after that to continue to hopefully get money towards that judgment. And then Social Security, public assistance payments, and some others, these are typically exempt by statute. So if that's the source of income and it's a bank account, not going to be able to successfully garnish those. So the memo of lien foreclosure process, and I'm going to try to hustle up through this. We're getting to about the bottom of the hour here. So the memo of lien foreclosure process, there is a statutory process if the owners don't pay the memorandum of lien amount. Typically, the owners are going to need to be given a written notice of the foreclosure. They're going to have 60 days within which to redeem that. And should they fail to do that, the association is going to have the right to proceed with a non-judicial foreclosure against the property. And so again, this takes place outside of a lawsuit. This is pursuant to a statute. There is going to be a good number of requirements for this. Typically, what is going to happen is a foreclosure trustee or a local lawyer who's uninterested in the dispute is going to need to oversee the sale. And there's going to need to be a notice of sale that's given in a local newspaper for several weeks at a time. And that's going to set forth the date of the sale and those sorts of things. And so if the owner still doesn't pay, then the association can proceed towards the sale. And so one thing to keep in mind is that what we need to do when we're doing a memorandum of lien foreclosure is we need to give notice to all the other lien holders on the property. Typically, this means purchase money mortgage lenders, so the owner's mortgage company. They'll need to get notice of this. And sometimes we see that when the mortgage company gets notice of this, they institute their own foreclosure proceedings. They take the position that that could be a violation of the promissory note that the owner signed. Now, importantly, by statute, the owner, even if they don't pay pursuant to the first notice of foreclosure, they have a right to cure or pay off the full amount due and owing under the memorandum of lien process up until the time of sale. And this is kind of frustrating for the association because if they go through this process, clearly there's been time and expense incurred, and the owner does have the right to pay even if it's on the eve of the sale. And if they pay, the sale has to stop. Now, if the sale goes through and somebody purchases the property, then the proceeds are going to need to be paid out by statute in accordance with lien priority. So typically this means, if there's real estate taxes that are owed or tax liens that are owed that are superior to the association's lien, those can be or will need to be paid. The costs of sale will need to be paid and those sorts of issues and those sorts of items. So there is a process of lien payment, and it gets fairly complicated depending on what liens may be encumbering the property. And so whether or not this is a viable option often depends on whether or not there's sufficient proceeds or would be sufficient proceeds in the property should it be sold. For example, is there sufficient equity in the home? And if there is, this is probably a better idea, this memorandum of lien foreclosure, than if somebody is, let's say, hopelessly underwater. Now, the frustrating thing is you may find that information out in debtors interrogatories. The owner may tell you, this is my mortgage balance. But if you're doing, let's say, just a memorandum of lien foreclosure and you don't know, we're probably not going to be able to know that information. We could do a title search that would disclose whether or not there's a mortgage or a deed of trust recorded as to the property. But typically, you don't see the balance as an ongoing matter being updated in the clerk's office. You may see the beginning balance, but you may not see the current balance, whether or not they've paid or fallen behind. It can be a bit of an unknown. And that begs the question that owners, or not owners, associations often ask is, well, can't you just call the mortgage company and ask? Now, this is a very logical thing to ask, but unfortunately, under the Fair Debt Collection Practices Act, we as debt collectors are prohibited from talking to third parties about a consumer debt. So we would not be able to pick up the phone and call the mortgage company ahead of time and say, hey, we want the balance on the mortgage. We want to see if this is a good idea. Unfortunately, Congress in that act has said we cannot do that. So it's a bit of an unknown when you go through that with respect to how much equity may be in the property. And usually a good way to go about finding that out is debtors interrogatories. All right, so judgment creditor suit. This is, as I mentioned before, sort of the nuclear option. This is when you have a judgment or judgments against an owner and they just will not pay, and you think either there may be sufficient equity in the home that we may get paid, or even if we don't think that's the case, we think that we need to sort of stop the bleeding, and if they're not going to pay the assessments, this is sort of the best option for the board. So this is obviously an option not to be taken lightly, because this is an option that involves a lawsuit in circuit court, so the higher trial court, where the parties do have the right to discovery. It takes a bit longer to get a hearing date. Lawsuits are lengthier, they cost more to draft. Typically, to draft a judgment creditor suit, you're probably looking at a few $1,000s to actually draft it, as opposed to a few hundred in the general district court collections context. So the law has changed on this very recently, and we've got the summary here on the slide. And the statute for judgment creditor suits was recently amended to provide that generally, if a debtor resides in the property that you're seeking to sell or have the court order to sell, if they reside in that property as their primary residence and the judgment is less than $25,000, exclusive of interest and costs, you cannot do a judgment creditor suit. But there was a carve out in the amendment to the statute for property owners associations, which is good news. You could do a judgment creditor suit if the judgments, one or more, total at least $5,000, exclusive of interest and costs. So that's still a higher number than I think many associations would probably want. And so for smaller associations, it all but destroys the judgment creditor suits where the assessments are lower. Because quite often you're going to see a situation where they're not going to be able to get a judgment collectively, even judgments, for over $5,000. But it's possible that if you're strategic about it and collect multiple judgments, you may be able to get to that threshold. If you get to that threshold and you want to pursue a judgment creditor suit, and this is something you really should talk through with your collections counsel of whether or not it's a good idea, the typical process is going to involve getting a title report for the property, which is a title examiner going to the courthouse, researching the circuit court land records, identifying the liens against the property, whether or not there's other judgments, whether or not there's a mortgage, because the lawsuit is going to need to name those lien holders as necessary parties because their interests are going to be affected by this lawsuit where you're seeking to sell the property. The owner would then be served with the lawsuit once it's filed. The owner would then have 21 days within which to file a response. If the owner fails to respond, the association could move for what's called a default judgment, but the association, because of the nature of the relief, is still going to need to put on evidence of what's going on, what is the title situation with the property, has there been any indication of payment, what are the judgments, etc. The owner can show up and participate in that hearing. So it still requires a court hearing and court permission. You still need to meet the test, the legal test. If the owner responds, retains counsel, this matter could be litigated for a lengthy period of time. substantial discovery can be conducted. My experience has been, however, that owners who are in this position, sometimes they don't respond, and sometimes they do go into default, and you end up having a hearing on the petition or the judgment creditor suit itself, where you need to put on the evidence and the owner may or may not show up. So assuming you prevail at the hearing and the court orders the property to be sold, then the property is going to need to be sold, and typically the court's going to appoint a special commissioner. Sometimes this can be collections counsel who represented the association in the suit. Sometimes it's a third-party disinterested lawyer. Then once it's sold, typically you're going to see the collections counsel retain a realtor or an auction company, get a contract, get court approval on that, list the property for sale, take the highest bid or the best contract offer, get court approval on that. Then you'll see the property sold and the lien holders be paid in accordance with statute. So these judgment creditor suits can take a good bit of time, sometimes several years, because there's a lot of moving parts, and sometimes it can be rather difficult to market these properties that are sort of considered distressed properties. Sometimes the owner is still living in the property, which can pose a bit of a practical hurdle for the realtor, for example. So it can be a bit more time consuming and a bit more costly, but this is essentially the sort of nuclear option for when an owner just will not pay. Let's say they've just stopped paying altogether and it's a real financial problem with the association. So it's a good option to consider in certain circumstances. So we've talked about the FDCPA, the Fair Debt Collection Practices Act. This is an important set of federal statutes and regulations to keep in mind. This does not apply to associations acting themselves because they're collecting their own debt. These laws and regulations apply to debt collectors, law firms like ours, arguably management companies. And typically what it's going to require is what's called a verification or a validation notice at the outset, where we have to give certain notifications to the debtor about their rights under federal law, their right to dispute it, and these sorts of things. So when we issue our initial demand letter, we include this FDCPA compliant language and just some basic, summaries, certainly not exhaustive, but by way of illustration, provides these debt collectors cannot mislead a debtor, can't threaten action that they won't actually take, like, for example, threatening a lawsuit if the association is not, in fact, going to do that. They can't issue a demand letter for any debts that are beyond the statute of limitations, and we can't talk to third parties about the debts of a debtor, except under very limited circumstances. And I know we talked about that a bit before. So this is sometimes a frustrating discussion that we have to have with board members, that this is why we have to give a 35-day notice in our demand letter. This is why we can't do certain things that you may ask us to do. It's because of these federal laws and regulations. So just wrapping up the collections portion, oftentimes we see boards conduct a cost-benefit analysis. And so for associations with modest assessments, very modest assessments, maybe of under $100 a year, typically it's worthwhile to consider pursuing a memorandum of lien just to make sure you're carrying out your fiduciary duties. There's nothing wrong with filing a warrant debt lawsuit as well. The judgment lien itself is more meaningful and gives the association more rights than a memorandum of lien, because if the owner loses the property in foreclosure, that memorandum of lien is typically going to be wiped out as an inferior lien. It will no longer encumber the property, whereas the judgment lien, if obtained, would survive any foreclosure with respect to the owner's personal obligation. You can still pursue it, in other words, against the owner. So usually a good idea to consider warrants and debt as well, even for more modest assessments. And with the statute of limitations being 3 years, once a delinquency approaches the 2-year mark and there's no judgment that's been obtained, no memorandum of lien, really prudent for boards to consider coming to some plan of action for what are we going to do about this delinquent account. We're going to do a memorandum of lien, we're going to do a warrant and debt, we're going to do both. Don't want to be caught in a situation where the statute of limitations expires. And then also important to discuss with your collections counsel, because it's part of this cost-benefit analysis, whether or not attorney's fees can be recovered in collections efforts. Quite oftentimes, declarations do provide for that. So if you're not sure, it's definitely a good idea to check. and check with your counsel if you're still unsure. And check with them anyway to see how that might play out as far as a fee recovery situation in a lawsuit. We often see payment plans from owners, and that's always great if you can come to a payment plan. We can draft those, we can review those. Capable Collections Counsel can do that. We do recommend you check with your counsel before you do that. Sometimes we see associations, they just sign those because there was a form somewhere. That may not always be a great idea because there may be provisions in there that are a good idea to include or maybe a bad idea to include. So always good and always worth working with your collections counsel. They can typically draft a form that, hey, here's one you can use going forward. If you have any questions, you can contact me, but here's some provisions we recommend. So we do recommend that. And payment plans, again, can always be an option if the association wants to pursue those, and sometimes they're a good decision. All right, so just wrapping up, again, keeping a delinquency report, going over those at board meetings, maybe establishing some collections guidelines for when to turn those over to collections counsel, applying the collections guidelines fairly and uniformly, not targeting folks. Again, this is all basic stuff and very important to comply with, but to the extent anyone needs a reminder, got to do it fairly and uniformly, double checking the charges and fees on the account statement, keeping copies of prior demand letters, reviewing payment plans with counsel, and again, periodic reviews with the board and collections counsel as appropriate. All right, so that's collections in a nutshell for this presentation. So jumping into covenant violations, and this will be much quicker. So covenant violations typically take the form of a violation of the association's declaration or also a validly promulgated rule and regulation. And so we represent clients on covenant violation matters, issuing demand letters, filing injunctive lawsuits or lawsuits seeking injunctive relief, seeking compliance with the governing documents. So first step, and this is down to the board level, down to the community manager level, even before counsel's involved. First step, documenting the violation. Highly recommend timestamp photographs. Highly recommend keeping copies of all prior demand letters or reminder letters. Those can be very important when it comes time to file a lawsuit if necessary. It's hard to rebut a timestamp photograph, but without a timestamp on the photograph, an owner can say, well, that wasn't the condition of the property then, and it becomes sort of their word against the board members or the community manager. So to the extent it's possible, timestamp photographs, prior correspondence, definitely keep copies of all that. That can be very helpful and persuasive in court. So if initial demand letters, even internal demand letters, aren't successful in remedying the violation, it's possible, if permitted under the association's governing documents and compliance with statute, that the association may have the option to take an owner to a due process hearing. And I'm sure many of you all are familiar with that if your documents provide for it. And generally, and there's a statutory process, there's certain notice requirements, the owner has certain rights to attend that. And if a violation is found, the board has the authority to make certain charges as provided by the statute, which are summarized there. Again, very important to check your governing documents. This doesn't mean all associations can do this. There does have to be authority in the declaration to do this. And if there is no authority to do it, don't do it. We recommend don't doing that. That can open the association up, obviously, for potential legal liability. All right, so if the demand letter process doesn't work, you try a due process hearing if that is permissible for you and still doesn't work, the association would have the authority to go file an injunction lawsuit in Virginia courts. An injunction is a court order saying, owner, you need to do something or don't do something. An injunction is considered an extraordinary remedy under Virginia law. So it's not automatic. It's up to the court. Court can say no. But generally, to obtain a permanent injunction in Virginia, associations need to show certain elements, including you don't have an adequate remedy at law, meaning a money judgment is not going to reimburse you or satisfy the damages that you're seeking. You need a court order. And that the equities favor the association, meaning generally the association has acted in good faith, they have done what they're supposed to do under the governing documents, and the owner is really the one that is offending the declaration and not doing what they're supposed to do. An injunction lawsuit can be filed in general district court or circuit court in Virginia. This is good news because you can file these in general district court, which again, as we talked about before, typically much cheaper and much faster to resolution than circuit court. So you can file in either one. In general district court, if either party wins or loses, the negatively impacted or the losing party has a right to appeal the decision to circuit court, as if that prior hearing or trial in general district court didn't happen. So this can be a frustrating thing for associations because let's say you try the case in general district court and you win, the owner can try to appeal to circuit court and then get a new trial. This can result in having to try the case twice, which obviously involves more costs and can be frustrating. But typically the advice I give is that if you think the owner's not going to show, or if you think the owner's not going to contest it, it probably makes more sense to try to file it in general district court because it's probably going to be cheaper. They may not show up, and it may just be an issue of how fast can they resolve it, not are they in violation at all from the owner's perspective. On the other hand, if you have a real sort of tough nut to crack, somebody who has counsel or will retain counsel will challenge this, and you know this is sort of their hill to die on, it may be best to just file it in circuit court, knowing that if you win, they're probably going to appeal it, or there's a decent likelihood you'll appeal it. And then by filing it in circuit court, maybe you could just avoid having to try it twice. That may end up reducing the costs in total. And so covenant violation lawsuits, one thing to keep in mind is that under the appropriate act, the Property Owners Association Act or the Condo Act, typically there's an attorney's fees provision that allows for a prevailing party to request an award of attorney's fees in such a lawsuit. But that's a two-way street. So if the association loses, they're on the hook for an attorney's fees award in favor of the owner. And the owner could seek fees against the association in such a lawsuit. And the association in turn would be able to seek an award of attorney's fees as well. So there is an element of risk that if the association loses, they could be on the hook for, or would be on the hook for the association's attorney's fees. So something to keep in mind and something we talk about with all clients when they're considering lawsuits such as this. You want your case to be strong. Because if it's sort of a toss-up case or a case that you're not really sure about, you don't think you have a good basis, it may well be that it's too risky from an attorney's fees perspective that you don't file the suit because you end up paying your own lawyer and you may end up paying the owner's lawyer if they win. So just skimming through, we talked a bit about discovery already, same rules in covenant violations. And if there's a trial, we would need to go through the governing docs, prior correspondence with the owners, any pictures, any other evidence. And that sort of thing. The owner would have the ability to put on their own evidence, cross-examine our witnesses, make legal argument. And so real quick, if an injunction is awarded in favor of the association, it's enforceable through the court's contempt power. So if the owner still doesn't comply with a court order, we can make a motion for a show cause, which is a summons to the owner to show cause why the court shouldn't hold the owner in contempt. So to file that motion for a show cause, we'll need sufficient evidence to say, Judge, you ordered them to move the boat. Let's say, for example, they didn't move the boat. Here's a timestamped photograph of the boat still there as of yesterday. Please issue a show cause and set the matter for hearing. And then if the court is satisfied, yes, there's sufficient evidence, the court will set another hearing for resolution of that show cause, whether or not the owner should be held in contempt of court, which means the owner could fashion a pretty broad remedy. Could award attorney's fees, could fine the owner, could potentially jail the owner for violation of a court order. So it's a good tool for associations once an injunction is obtained that if an owner still doesn't comply, we can make a motion for a show cause. And that wraps up covenant violations. So I'm sorry that went a bit longer than I anticipated, but it's a good amount of information to cover. Happy to answer any questions at the end, and I'll kick it off to Greg.
All right, thanks, Brett. Appreciate it. Everybody, I'm going to go over a few issues related to meetings. Hopefully, just highlight some tips and tricks that can make your meetings go smoother, help you approach some challenging situations. I'll take about 20, 25 minutes, then we can open it up to questions and comments, anything y'all might have. So what I wanted to go through was to go through executive session, meeting minutes, owner forums, quorums, and virtual meetings. And pretty much how I did this was the Common Interest Community Board, they put out opinions. So they'll get reports from complaints from homeowners, and then they have the power to investigate boards and what they're doing. And if you go and Google it, the Common Interest Community Board, they come out with, 10 or 15 decisions every year that are really, really informative. That can really help board members see, this board did this thing wrong here. Maybe we should think about that. And sometimes they're kind of entertaining, some interesting owners bring up issues, but also some boards not quite doing exactly what they should, and so it can help you with some pitfalls. So what I did here was I went and looked up the most recent 5 or 10 of them and kind of pulled what's going on to kind of help you get some idea of how you could manage your meetings. So the first one is regarding executive session. And many of you, when you were appointed to the board, maybe you had never been to an association meeting before. Maybe you'd never really been to a type of business meeting where you might have executive session or meeting minutes or presidents or anything like that. And this is your first foray. Now, luckily, you have a team like EJF that is going to do a great job at helping you, navigate that and learn. And when you make a misstep here on this procedure, they're going to be there to help you out. But there may be times when EJF might not be around, or you're kind of doing things, and you might need to know a couple things here and there to navigate. So with respect to executive session, that's a confidential time that the board can get together and discuss certain things. Personnel matters. You can talk with your lawyers in there. You can talk about contracts, pending contracts. You can talk about violations in the community. You might not want to talk about that in an open meeting if you're thinking about bringing a lawsuit like Brett was talking about. You don't really want to talk about that in an open meeting. And then also your own personal liability. If there's been some accusations of fiduciary duty breaches or something like you're not doing your job, you can talk about that there. So the important part about executive session is properly going into executive session and properly getting out of executive session without violating any of the rules. And this is where a lot of boards get mixed up with the report to the common interest community, is they don't vote properly, they don't talk about the right things, and they don't do the right things when they get out of executive session. So the first thing that you do is you have to vote in an open meeting to go into executive session. So someone has to raise the motion, you have to vote to go into executive session, and you have to talk about why you're going into executive session. So you have to tell the owners who are present why you are doing what you're doing. And so when you do that, you want to make sure it falls under one of those categories. And then when you're in executive session, those are the things that you're talking about. You're not talking about other stuff that should be in open forum. And then when you do that, you want to make sure you include that in your meeting, so that when you go in your meeting minutes, so that when you go back and someone says, oh, you didn't vote, or you didn't talk about what you were going to talk about in executive session, you have that data to go back and say, no, we did it. Everything's above board. Now, one thing that you can do, you can vote on certain things in executive session. But if you make that vote in executive session, you have to make that vote again outside of executive session. And you have to tell the owners enough that they know what the matter is generally about. So generally, what are we going to do? Now, you don't have to reveal everything that's talked about in executive session. Of course, you shouldn't, because that's all private. But if you vote to bring an action against a certain homeowner, then you're going to have to vote. The board, someone raises a motion: are we going to bring an enforcement action against this lot or this homeowner? Then you have to vote on that. You don't have to say why you decided to do it. You just have to give reasonable notice as to what it is, so that the owners know what you're voting on. Some boards, they will vote in an executive session. They'll come out of executive session and they will report how the vote went, but that's not proper. You can't just report how the vote went. You need to actually have a vote outside of executive session. So you don't want to get tripped up by that, by making a vote and then coming out and not making that vote again. So executive session is a really important tool to make sure things are kept private and confidential, especially communications with your attorneys. But you definitely need to make sure you're following the rules so that you don't get tripped up and be accused of not following those rules properly. So the next is with respect to meeting minutes. So the code requires associations to keep minutes of meetings of the board of directors and make them available to members upon request. And you have to keep them open for inspection and copying within 60 days of a meeting. And the trick with meeting minutes is there's not a whole lot of guidance as to what they need to include, how detailed they should be. So the Common Interest Community Board came out with a recent decision that basically says, well, the code doesn't really tell us, but Virginia's Freedom of Information Act, that gives a good idea of what should be kept in meeting minutes. And that doesn't relate specifically to common interest communities, but they say this is a pretty good guide. Now, the trick is this is not supposed to be a play-by-play of everything that goes down. You know, when Mrs. Johnson stands up and excuses herself, or, you know, this board member sneezes or whatever, you know, it's not supposed to be just a line by line. It's just a general of what happened. Someone brought up this motion, a vote occurred on this motion, owner forum, owners voted to go into executive session. So just a general line by line of what happened. This contract was discussed, you know, and it's just basically to give a roadmap of what occurred. So this is what the Common Interest Community Board says you should include. Date, time, and location of the meeting, the members of the board who are present and those that are absent, who participated electronically, a summary of the discussion on the matters proposed, deliberated, or decided, and a record of any votes taken. And that really was it. So this could be really useful because your secretary isn't, first of all, your secretary is a board member too. And so you don't want them frantically writing down everything and not able to really participate or think critically about what's going on in the meeting. So your secretary can just take bullet points as you go, and that way they can participate. Additionally, the more you include, the more cumbersome it gets for the members and for the owners to complete and to finalize. You're going to have to vote on them later to incorporate them, and you're going to have to go through in detail, make sure, oh, did this really happen? I don't remember exactly. Did this really happen this way? Whereas if you keep it more general, it's going to be a lot easier for you to keep your minutes. It's going to be a lot more simple, and you won't have to stress out about it so much. The next part is owner forums. So there, in every meeting, you have to have an opportunity for members to comment on matters relating to the association. If the board limits the agenda of what's going to be at the meeting, then the board can also limit the owner forum to those particular topics. Now, of course, you're going to have your annual meeting that all the members are invited to, but members, the Common Interest Community Board likes to say, everything that happens in association happens in the light. Nothing happens in the dark. And so we do everything in the open. And so owner forum is part of that. The board can adopt reasonable rules relating to owner forum. That can include certain time limits, both on the duration, because you just don't have time to hear 20 minutes from 100 different owners. It's not possible. And so you can limit how long, what duration of time the owner forum is going to be. You can limit how long a certain person can talk, depending upon whether it's reasonable or not. So of course you can't limit somebody to 10 seconds. It has to be neutral. You can't limit, certain sections to some time, or you can't bar somebody that is in good standing with the community from talking and hasn't violated the rules. So they have to be reasonable and neutral, but you can have those reasonable rules. So the important thing to remember here is this is not a time really for the board to engage with the owners. It's a time for the owners to talk about whatever they want to talk about, and for the board to receive that information, but not necessarily to respond to that information. And that's really challenging for board members because you got on the board for a reason. You want to help the community, you want to make it better, you want to resolve problems. But the problem is if you get in that back and forth, then that sometimes escalates tensions. You might not have the time to really process or talk with counsel or your management company about how you should handle certain questions from owners. And so the best thing to do is when an owner's done speaking, just thank them for their time and call the next person. You don't really need to engage. Now you can if you want. There's nothing in the rules that say you can't. It's just easier, and if you want to have a smooth meeting, to kind of run it that way. And you can remind the owners too, if they start asking questions and get aggressive, you can just remind them, we're not answering questions during the open forum. We appreciate your feedback and input, and we will utilize that when we make our decisions. And the second thing that's really important is just have a plan for unruly members. Many of you probably have members that love to come to your board meetings, and they love to talk during open forum, and sometimes they get a little excited and heated. And so it's important to have a plan for that. And the plan may include something as simple as, how are we going to invite someone to stop speaking? What's our tone going to be? What are our words going to be? Who's going to be kind of the enforcement mechanism from our boards going to do that? Can we get our management company to help us out on this? And then if someone continues to be a problem at meetings, can we invite counsel to a meeting who might be able to intervene and talk about the law and what this owner forum is for? And then sometimes you come to extremes where you have somebody that is so extreme and is prone to violent outbursts or threats. Sometimes I have seen boards that have had police on hand just in case. Hopefully, cross your fingers, it never comes to that. But sometimes you need to, and you're bound by law to have these owner forums, so you can't just stop them. But you can, and your reasonable rules can restrict people based on their past, if they've violated the rules in the past. So of course your rules are going to say no violent threats, no outbursts, etc. So if somebody continually violates those, you can restrict how they participate in open forum. This is kind of a quorum. There's not a whole lot of tips about how to achieve a quorum, but a quorum is the minimum number of board members or members of an association you need to have a meeting. So EJF, your management company, is really going to help you with your annual meetings to make sure you have enough people there that can vote, that can hold the meeting. But as far as board members, what you need to make sure you do is before you call a meeting or hold a meeting, you want to have a quorum of your board present and available. And so if you poll the board members about their availability, you don't want to, you have 10 board members, you need 5 to achieve quorum. You're not going to schedule a meeting when 7 of you are unavailable. So that's just practical. It's always maybe not embarrassing, but inconvenient if you go to a meeting and you can't get a quorum, and then you can't have a meeting. So you definitely want to make sure you have a quorum, and that's just coordination. And your management company can help with that too if you need, to communicate with the board members to make sure they're all available. And then the last one before we kind of wrap up talking about rogue board members, this one I think is really important for board members, because how you conduct yourself, every action that you take as a board member is supposed to be, except an executive session, is supposed to be open to the owners. Like I said, the Common Interest Communities Board says everything's done in the light. And so there was a recent decision by the Common Interest Community Board where board members were texting each other, calling each other on the phone, emailing each other about association business. It didn't say specifically, but that would be things like contracts. It could be lawsuits that should only be done in executive session, et cetera. And the rule says all meetings of the board where business is conducted must be transacted in open to the members of the board. And so the board admitted, yeah, we're using emails, we're using text messages, whatever. And the Common Interest Community Board said, well, then all your emails and text messages and phone calls, those are all subject to review by the owners or by the members of the community. And so you can see how that could be a problem, right? If you're not thinking these are going to be open to the public and you're informally saying, oh, hey, this and that, maybe you have some personal information in there. Maybe you're talking about an owner who constantly violates the rules in not so flattering a light. And you really don't want to open up those private communications to inspection by your members or your owners. And so when you're transacting business, you should really try and do it in a meeting. Now, of course, EJF, your management company, they're going to help you by distributing packets and information that you can review privately. Bids on contracts, for example. Let's say you have 2 bids from a landscaping contract. EJF can help send those to you and distribute those to the board, but you're not going to be texting, your other board members and saying, oh, that I really don't like this because of XYZ. You're going to talk about that in a meeting. You're going to have a meeting about that. And you're going to make sure that you give the proper notice. And maybe if it's, if you hold a meeting just on a landscaping contract, as long as you follow the rules right, sometimes nobody's going to attend, and then you're in an open meeting, you can talk about it all in person. You don't have a written record except your minutes, and that's just it. So it's just a whole lot easier if you avoid those kind of text messages and emails when you're transacting business. You should try and be formal as possible. Additionally, the court or the association can hold virtual meetings. You have to have rules set out and procedures for how that's going to happen. And so, we help associations all the time draft those up. They're pretty standard and simple, but you have to have them pursuant to the code. And the trick here is that all of the members have to have the ability to participate. So if a member does not have either the capability or the desire to attend virtually, so they can just say, I don't want to attend virtually, the association has to make a reasonable alternative for them. So a lot of times if somebody wants a reasonable alternative, what they'll do is most people will be virtual, but then one person might be in person to help people that don't want to attend virtually. But with our, current technology, many homeowners appreciate the ability to attend virtually. And so a lot of times you can achieve a completely virtual meeting, so long as you give them the proper notice and nobody says they don't want to, and that can just make your life a whole lot easier. Additionally, that can be really useful when calling meetings about, discrete business things that you just need a quick answer on. You can give that notice out of a virtual meeting. You can all meet virtually quickly, and make that decision and then close the meeting. So virtual is a really, really useful tool, and it's encouraged if you can do it right and well. It can really help things move along smoothly. So the last thing, and just the last 5 minutes before we close up for questions, hopefully you don't ever encounter this, but you might, is you get a director that we call a rogue director, a director that is doing things their own way, not following the rules. And oftentimes this is a disgruntled owner that, had some beef with the association about something. They get voted onto the board, and then they're throwing their weight around in ways that are not proper. The director, now, this doesn't mean that a rogue director isn't one that has a strong opinion or, one that wants change. Those are not rogue directors. You're going to have disagreements on boards, and that's just the way it is. But a rogue director is one that looks like they're violating the rules. They're not willing to follow the rules. They might be violating some fiduciary duties. They're not listening to advice of counsel or the management company. And so these rogue directors can create a risk, and it's really important to help manage them very early. And because you don't want to open up yourself to potential liability. You know, if this rogue director is willing to violate their fiduciary duty, you don't want to be pulled into that problem at all. And so to deal with a rogue directors, the first thing is to try and de-escalate it on your own. You know, hopefully they're reasonable enough that they'll at least talk to you about it. And that's the best way to de-escalate it, because it can build a sort of rapport within the board if you can all work together. And so that would be the first step. The next step would be engaging fellow board members to help as well. And along with that, the community manager can be especially helpful to help you with these types of board members, because the community manager is designed to help the whole board get along and do what they need to do and guide them through the process. So sometimes someone just needs a third party to tell them, no, this is not how you do it. You are potentially opening yourself up to certain liability. And EJF has a lot of respect of very experienced individuals, and hopefully the board member would, you know, respect that experience. Sometimes you do have to get legal counsel involved, and you can go into executive session and counsel. You know, it's our job to tell you how it is, and we have to ethically, we have to give you good legal advice. And so we can talk directly to the rogue board member and say, look, you're having this problem, you're opening yourself up to liability, you're opening up the board to liability. We recommend that you do XYZ. And that can be very powerful too for them. And then the last couple things, if that just doesn't work, you can do something what's called a censure. You might have heard that with like respect to government, like someone gets a censure in the House or something like that. And that's an official, basically a reprimand. And that does a couple things. First of all, if you've got this far, it might not stop them. But what it does is it creates a written record that you do not approve of this conduct and you are not going to participate in this conduct. And so it's really a shield for board members to avoid liability, because you want that. First of all, you're going to put it in meeting minutes. You know, we're going into executive session to talk about, you're not going to disparage the board member in front of the owners, but we're going into executive session to talk about the role of boards of directors, et cetera. So you're going to have the meeting minutes, but of course they're not that detailed, right? So a censure is really going to put in writing, we do not approve this, we are not a part of this. And then finally, if you just can't get across that, you know, that threshold to get the rogue director calm down, you can seek to remove them. And you're going to look at your governing documents on how you can remove a director. You might have to have a vote. Sometimes a majority of members can remove, or a majority of directors can remove another director, depending upon the circumstances. And so you need to look at your governing documents, talk to your management company, talk to counsel to help you navigate the best way to do that. You know, and that might be an awkward conversation, right? When you're in an executive session, potentially with a board member present, but that's the best place to do that too, to talk about that, because you don't really need to air that dirty laundry out in front of the owners. You want to try and keep it as calm as possible. So that is, there are some more extreme remedies, going into court, seeking injunctions against them, seeking for them to stop. It's exceedingly rare. I'm actually not sure I've really seen that practice, because typically, you know, you have good professionals around you that can help calm that down. And with that, I think that will conclude our presentation. So we hope that you found it informative. You took some tools. If you want, you can talk with Josh afterward, and he can provide these slides to you or your other contacts at EJF, so you can have these for reference. But hopefully you found this useful. We're always available if you have a question. Hey, you said this, I'm not sure what you meant by it, etc. Of course, we always have to provide this disclaimer that we're not technically your attorneys. We're giving, open legal advice, or we're giving open suggestions, but not specific legal advice. So, yeah, so I will close it off. We'll turn it over, I think, back to Josh to see if he can open up to any questions. But otherwise, appreciate everybody for participating.
Really appreciate it, guys. Thanks so much for taking the time to do this with us. I'm going to open this up. It looks like we've got one, maybe. Let's see who we got here. Lois, you should be unmuted there. There you go. The floor is yours, Lois, if you wanted to ask a question. All right, I'm not hearing. If you want to type it into the chat there, we can try to get back to you. All right. Anybody else? All right, not seeing anything. All right, well, good deal. Well, we'll go ahead and wrap up. For those that are in attendance, we'll make the recording, the slides available on the EJF website. So you'll be able to access that. There'll be a link. We'll have that information available for you. Again, Greg, Brett, really appreciate y'all taking the time. I know you've got busy schedules and took a lot of time putting this together. So thank you again for your time to do that, sharing your knowledge and insight with us, with our clients. Really appreciate that. Everybody who was in attendance, thank you for taking time out of your day. We definitely believe in providing this kind of educational opportunity to support our communities. And again, thank you again. And with that, we thank you. Enjoy the rest of your day. Thank you, everybody.
Thanks, everybody. Appreciate it.
Bye-bye.
Y'all take care now.